Athenaeum for our discussion of Evenwel versus Abbott. For the past couple of years, the Rose Institute has sponsored Athenaeum talks to discuss major cases pending before the U.S. Supreme Court on topics related to voting and elections. The first one was a panel on the Shelby County case, challenging a portion of the Federal Voting Rights Act. The second was a panel on the challenge to Arizona's Independent Redistricting Commission. Today, we've organized a discussion of Evenwel versus Abbott, a case out of Texas, now pending before the Supreme Court with oral argument scheduled for December 8th. The case raises interesting and important questions about the one-person, one-vote standard for legislative districts. To discuss the case, we have invited one of the nation's leading experts on election law, Christopher Skinnell. Chris Skinnell is a graduate of CMC, class of 1999, where he, among other things, worked as a research assistant at the Rose Institute, and he went on to get his law degree at the University of Chicago Law School. He is now a partner with Nielsen, Merksimer, Parinello, Gross, and Leone, based in Northern California, which is one of the nation's leading political and government law and lobbying firms. His practice includes litigation and counseling related to elections, state and local initiatives and referenda, redistricting and voting rights, and campaign finance. He has advised scores of counties, cities, school districts, and special districts on compliance with state and federal laws governing redistricting and voting rights, and has filed amicus briefs in several leading voting rights and redistricting cases before the United States Supreme Court. It's a pleasure to have him back on campus and here at the Athenaeum today. So the way I thought we'd set this up, I've asked Chris to give some background about the Evenwel case, and then we'll have some discussion back and forth, and then we'll open it up for your questions. So welcome, Chris.
All right. Thanks, Ken. Thank you, Ken. It's always nice to be on campus.
Yes.
Just a little bit by way of background, the Evenwel case raises a question that has been surprisingly unanswered for a good 50 years, since the voting rights revolution of the early 1960s. In Reynolds versus Sims, the Supreme Court said that the Equal Protection Clause requires that there is supposed to be substantial equality of population amongst legislative districts, so that the voting rights of certain voters aren't diluted by the fact that they are mixed in with a large population, and then voters in another district have a much smaller population and can exercise more influence. And over the years, that standard has been refined some by the court. The court has laid down a rule that, generally speaking, what you do is you take the relevant population of the jurisdiction and you divide it by the number of districts you're drawing, and you use that to get the ideal size of a district. And then you figure out how much each of the districts deviate from that, plus or minus whatever percent based on the population within them. And if the difference between the largest district and the smallest is less than 10%, then it's presumptively constitutional. It doesn't mean it can never be challenged, but generally speaking, it's going to be upheld unless something really strange is going on. But what the court has never definitively answered is, what's that relevant population that you're dividing by the number of districts? If you go back to Reynolds versus Sims itself, the language could be read either way. Most states over the years have used the total population of the jurisdiction as reflected in the census, including children, including non-citizens, including anybody and everybody who resides in that jurisdiction on April 1st of the year they do the census. The Census Bureau even counts tourists. If they're there that day, they count as a resident of that state. And some states make adjustments for that. The one case the Supreme Court has ever addressed on this came out of Hawaii. Hawaii, for maybe obvious reasons, has some unusual issues with respect to those sort of transient populations. And it was the early 1960s. They had a large military population, as they do, and a lot of tourists. And so recognizing that if they were to use total population, Oahu would very much distort the redrawing of their Senate districts, they decided that they were going to use registered voters instead, and they were going to use that as the benchmark for what the equal population would be. The lower court struck it down and said, no, you have to use total population. The Supreme Court said, no, it was okay, that you were not required to use the total population. You could go ahead and exclude military or prisoners who were not entitled to vote, or aliens, they said. But there were some caveats. The court said, you know, in this case, we think that registered voters really isn't that different from what you would get anyway, all that much. So we're not too worried about it in this case. Oh, and by the way, we're not saying anything about the next case. And they were very explicit about that it was really limited to its facts. And they were also very concerned about the use of registered voters specifically. And the court said, if you want to adjust to address sort of eligible vote, what we think of now as eligible voters, people who are citizens and who are of age and who could at least register to vote even if they're not, that's fine. But when you start to focus on registered voters, there are concerns about manipulation of those numbers. And you have to think back to the context. This is the early 60s, right? It wasn't Hawaii that they were so concerned about. It was Alabama. It was Mississippi, where people were prevented from registering to vote, even though they were at least theoretically eligible. And so they were concerned that if registered voters was used as the measure, that could be easily enough manipulated. And the court said, you know, made a comment that was really what the lower courts have taken away from it over the years in general, which is that it saw no particular reason in the Constitution to choose between total population or registered voters, with the caveats that if things got crazy, they were going to step in, basically, to be more colloquial than the court would be. And so that's really, as far as the Supreme Court stands, where things are. There have been a handful of cases over the years that have addressed the same issue. There was one out of the Fourth Circuit in the mid-90s, a couple out of the Fifth Circuit, both of which have come down to the same bottom line, which is they're not going to second-guess whatever the legislative body chooses as its measure of population. The lower courts have concluded, most of them, that it's essentially a political question. You know, it's a question of philosophy. Is the equality that the Equal Protection Clause guarantees an equality of representation, and so that everybody who lives within this district has equal representation compared to everyone in the other district, or is it a matter of voting? And the reason this comes up is, you know, and this has been getting more and more pronounced over the decades, is that now we have jurisdictions. California is a perfect example where you have the same number of voters in two separate districts. You know, state senate is about 800,000 people, but the number of people who actually are registered and cast ballots vary wildly. In the Texas redistricting case, the one that's before the court now, it's, you know, there are some districts that have 50% more registered voters than some of the others. And as I said, the lower courts have traditionally been disinclined to engage in that. There was a 2001 case out of Houston that took that position, and the Fifth Circuit said, we're not going to make the decision. The Supreme Court refused to hear the case, but Justice Thomas did issue a dissent and said, you know, we should really decide this. This is not an answered question, and we should at least give some guidance to people on how to do this. But they never did take it up until now. I will mention that there were a couple of cases, the Ninth Circuit and the Supreme Court of California, that did say, we are going to get involved, we are going to decide, and it's total population. It's the equality of representation is the important thing, not the equality of votes. And there were some, you know, unique facts related to state law that sort of tied to that, you know, so there's a question how much you could broadcast it out as a general rule, but those have sort of been floating out there, and those have guided redistricting, at least in these states, in the Ninth Circuit for a long time. And so the Evenwel case really basically finally tees up this question that Justice Thomas was wanting to answer back in 2001, which is what is the relevant population for deciding what equal population is.
Good. I'd be interested in hearing just a little bit more about the particular circumstances that this case presents. Who are the plaintiffs? And I assume they come from a district that has, although equal population, probably more voters than other districts in the state of Texas. And can you just say a little bit more about that?
Yeah, the plaintiffs, so Texas, I mentioned how you figure out your ideal population, then you figure out the difference between the largest and the smallest. And if it's under 10%, it's presumed to be constitutional. Texas, if you measure by total population, has a total deviation of its plan of 8%. So if that's the measure, it is presumed to be constitutional. But the plaintiffs in this case, one is from Senate District 1, one's from Senate District 4. Senate District 1, if you measure by eligible voters, sort of citizen voting age population, has, I think, 30% more registered voters than the ideal, which means 50 or 60% more than the smallest. And Senate District 4 is even larger. It's close to 50% more than the ideal. So you're talking about potentially a swing of as much as 100%. If registered voters are the measure, then it's a huge gap. And what's interesting is the plaintiffs haven't said that total population is irrelevant. They're not asking the court to say, do citizen voting age population and ignore total population. Their argument is that in Texas, it's possible to draw lines that you can do both. And that you can stay within the 10% in total population, but not have anywhere near these sorts of disparities in the registered voters, and that the state should have balanced both of them.
So is that realistic to be able to balance both of these standards, total population and voting population, given the way population clusters?
Well, I'll tell you, based on my experience, if that was the only thing you were worried about, yes, you could do that. Generally speaking, you could find a way to make that work. What you run into, though, is all of the other stuff that you're concerned about. You have to comply with the Federal Voting Rights Act, which is the big one. And then there are all the normal traditional redistricting criteria. Most states have a rule against splitting counties as much as possible, or a rule about not pairing incumbents so they don't have to run head to head. The courts have said that's a legitimate thing. Or any number of other sort of just general good government standards. Compactness, contiguity. Those sorts of things really are going to constrain you. And so when you start to add an additional variable, it becomes tougher and tougher to meet all of those criteria at once. And obviously there's some play in the joints.
Right. So it seems in this context, in particular, the Voting Rights Act requirements would be in tension with the theory of the case of the plaintiffs. Can you say a little bit more about what the Voting Rights Act requires?
Yeah. So generally speaking, Section 2 of the Voting Rights Act requires that districts not be drawn in a way that dilutes minority voting power. And the way that typically comes up is there's two ways to do that. You can either crack a minority population. You have a cohesive minority community, and you divide it in half so that instead of controlling one district, now it's split between two and can't control either of them. Or you can do the reverse, which is known as packing, where you could theoretically have a large enough group that could control two districts, but you cram them all together into one, so you really limit their power. And the Federal Voting Rights Act allows for a cause of action to challenge either one. So if you are wasting minority votes in an extreme way, or if you're dividing the minority community in a way that precludes them from having the sort of equal opportunity to elect that everyone else does, then that judges will step in and they will redraw the lines if need be. The Supreme Court has said that unless you can draw a majority-minority district that's at least 50% plus one of the citizen voting age population, then you don't have to worry about it. But if you can, then you have to be focused on that, and that's going to limit to some extent what you can do. And it really ties into this because if you're focused on citizenship and who can vote, because a lot of this is being driven by citizenship, the Latino community in particular in Texas is where this is really being an issue. And the more Latino areas where you have to be concerned about your minority-majority districts are also the ones where you have this citizenship issue. And so if you start taking out those citizenship numbers and expanding the size of the districts, it's going to be harder and harder to draw those majority and minority districts.
So in a sense, compliance with the Voting Rights Act is creating some of the skewing in terms of the disparities between the districts among between the percentage that are eligible voters in the districts.
It is.
Okay.
In fact, that's an issue in a companion case. There's a Supreme Court is on the same day that they hear this decision is going to hear a case against the Arizona Redistricting Commission's plan, the state Senate plan. And in that case, the courts have said, or the state has said, well, we underpopulated these districts here in the more urban areas to comply with the Voting Rights Act. They were a state that had to get Department of Justice approval, but in theory, it could be the same issue for anybody. So we underpopulated them to maintain the voting power of Latino voters in Arizona, which meant we had to overpopulate all of these outlying areas to meet one person, one vote standards. And the plaintiffs have challenged that, and they've said, you can't just systematically do that and, choose to dilute our votes, essentially, by systematically overpopulating certain parts of the state for that purpose. And the Supreme Court is going to hear that challenge in December as well.
So I'd like to ask you a little bit more about how interest groups line up on this. First of all, who were the ones that decided to bring this case in the first place? Is this a theory that's been developed over time, or is this kind of new, out of the blue? And who are some of the people filing briefs on behalf of the appellants in this case? And then on the other side, who are those who are resisting, and what are the reasons for doing that?
Sure. It's kind of a classic case of where you stand depends on where you sit. It breaks down along pretty partisan lines in this case, the state of Texas. The case was brought by a conservative advocacy group, same group that pushed the Shelby County case a few years back and has done a number of other related cases. And they went out and they found the plaintiffs, and they've been pushing it. And the amicus who are supporting them are sort of the who's who of the conservative academic and foundation world. The Cato Institutes, Mountain States Legal, a lot of those other organizations on the more traditionally conservative side, and the people who are supporting the state and saying no, total population was an appropriate measure are the more traditionally liberal groups, the NAACP, MALDEF, the ACLU. So it's not lost on anybody that this has partisan implications, at least in this case. And the expectation for Texas, at least, is that if they move to a citizen voting age population instead of total population, it's going to benefit the Republicans, because the urban Democratic districts are the ones that have the fewest registered voters. To comply with the rule that you try to balance that out, you would have to expand them to take in more probably Democratic voters from right around there, and that means that you're going to have more ability to draw Republican districts out in the outer areas.
But it is somewhat interesting. If this case had been brought in California, the defendants would be a Democratic governor and a Democratic legislature. In Texas, these are Republicans defending the redistricting, right? So.
Right. Yeah, and it was drawn by the plan itself was drawn by a Republican legislature and signed by Governor Perry. So the Republicans have no particular complaints in Texas, and I don't know. I think they would rather just have the certainty of the plan they've already got, at least from the elected officials' perspective. But it's maybe a little bit of the split we see in Republican politics a lot now between the more establishment and the more ideological groups.
Are you able to tell in the Texas case what practical difference it would make in terms of the party allocation of seats if they went to this other standard?
I'm not sure exactly how exactly the full extent of it. I did see some numbers suggesting that if you did reapportionment, not redistricting, but reapportionment based on citizen voting age population, that Texas would have 4 fewer seats in Congress. So that gives you some idea of sort of the scope of this issue at the very least. It doesn't tell you how you would redraw them and what percentage of those districts would necessarily switch. But it is a significant portion of the population that would be affected. In Texas, California would be even more significant. The projection was that California, if you base it on citizen voting age population, would lose 6 seats in Congress out of 53. So it's a not insignificant number.
So one of the issues in the case, and there are briefs filed on this point, are the practical challenges of finding people and counting them, right? So the census is required in the Constitution. It's a decennial census, and it has a total population standard, and so it's uniform across the country. Everybody has to get that census data information. What are some of the measures of alternatives that the appellants in this case are seeking to use if they're not wanting to use total population?
Sure. They have proposed a few different options, right? One is registered voters for simplicity's sake, although the Supreme Court has been concerned about that. So they are proposing that as one possibility. Or they're proposing citizen voting age population. And part of the issue you alluded to, that some of the amicus who are defending Texas are saying, total population we have pretty good numbers on, right? The Census Bureau is required by law to go out and count every single person every 10 years. And we know they miss people, and we know they're not perfectly accurate, but they're pretty good numbers. I mean, reasonably reliable. That's not necessarily true with respect to the other measures. So if you're doing registered voters, for example, Nebraska doesn't have registration for its voters. So I suppose now the Constitution would require them to have some measure of registration, I guess. I mean, I would be surprised if the court went there. But that state, at least, doesn't collect registration data at all, so it doesn't have that available. Other states don't do a good job purging their voter files for people who have moved or died or anything else. And so those data aren't always great. If you do citizenship, if you look at your Census Bureau form, they don't ask about citizenship at all. And it's a conscious choice because they want people to answer it without worrying about being reported to the immigration authorities. I mean, it's a policy decision not to do that, although there's talk they may go ahead and do it in future years. So what the way they calculate citizenship is an annual survey of 1 million households across the country. And they aggregate those data on a rolling basis. So, the Census Bureau publishes what's known as the American Community Survey, and they do it in 1 year, 3 year, and 5 year increments. And depending on how many years you have involved, they report those numbers on smaller and smaller geographical levels. So the 1 year is only, I think, 60,000 people and above, cities of that size, which is not going to do the job. It won't help. You need much more fine-grained data to be able to do redistricting than that. The 3 year gets smaller. It gets down to maybe 10 or 20,000, I think, and some counties and things like that. It's only the 5 year data that really get down even close to the level of fine-grained data that you're talking about. They do reporting in what's known as a census block. So the Census Bureau reports its standard numbers in what's known as a census block group. The Census Bureau reports all of its numbers in what's known as a block. And it's basically, in an urban area, a city block. How many people are there here? How many people of certain ethnicities, certain ages, et cetera? And what you do in redistricting is you start taking those blocks and you put them together until you have enough population for a district. But the Census Bureau also has larger groupings. And so they have what are known as block groups, which may be 8 to 10 census blocks combined, and they'll report different things in those larger groups. And so citizenship data are reported at that block group level. And so if you're trying to do districting, you have to figure out a way to break the information that's reported at that large level down to the individual census blocks. It usually involves some level of attribution on a population basis or a geographic basis or something like that. And it's something we do. I mean, we have to try and do that for Voting Rights Act compliance. It's not a completely unheard of or unusual process, but it's not perfect. You know, because the American Community Survey isn't a total count, it's a survey. It has a pretty good sized margin of error, and you make an even larger margin of error when you start to trickle it out, you know, by this attribution. And you remember it's 5 years. So, you know, when I have the American Community Survey from 2005 to 2009, which is what the last go-around was, it's not who's there in 2009, it's who's there kind of in the midpoint, basically. You know, if you're, you know, you have a pretty good idea of who was there in 2007, approximately. But it's good enough for government work, for testing, you know, a lot of what you're doing. But the point that those academics are making is, if you're going to be redistricting on that basis, these are not reliable enough data. And there are some demographers who put in a counter brief and said, no, we do this. This is a well-accepted methodology. We think it is reliable enough.
Okay, so the census can get you total population and can get you voting age population, because
Right.
you have the age on the census.
Right.
But it cannot get you citizen voting age population. And so that's where you would have to go to the American Community Survey or some other measure as a substitute for the census, or you'd have to change the census.
That's right.
And are those on the table as options that the court could require the census to be changed to achieve this goal?
I don't see how. The Constitution says that there has to be an actual enumeration of people every 10 years. So it requires that the total number of people be counted. And the court has very affirmatively said, you know, in some of the cases related to sampling, no, you know, you can't do statistical manipulation. It has to be an actual count of people. Beyond that, there's nothing in the Constitution that would require Congress to fund anything like that for the Census Bureau. In fact, there's always some talk about them defunding the American Community Survey, although they use it for allocating, you know, goods and services and everything else. I would be surprised, but it could happen. There's nothing that prevents Congress from saying, you know what, we're not going to sink $100 million into the Census Bureau to collect those data anymore, and then you're left with nothing.
I'd like to circle back to a point you made early on about the two theories of representation, or two theories of what we should be looking for in the one person, one vote standard, and that is equality of representation, which would be a total population measure that each representative represents an equal number of human beings, and then the voting equality, because a lot of the language in Reynolds versus Sims speaks to the notion of wanting there to be an equally weighted vote, and that there not be vote dilution, that each person's vote would count the same as another person's vote. And if you have these broad disparities between districts and the number of people that voting, you could argue, and this is the theory of the case, that there is a dilution of the voters in districts where there's a lot of voters as opposed to those where there are few voters. And so what's your sense of both the constitutional law on this and the way the court will think about it, weighing these two different theories of representation? I'll also just note that there's a Ninth Circuit decision in the Garza case where there's a concurring opinion by Alex Kaczynski, who's I think an influential federal appellate judge, where he raised this issue and said he thinks the better reading of Reynolds versus Sims is that we should focus on voter equality as opposed to representational equality. That, again, has not been considered by the U.S. Supreme Court. This is a case really of first impression. But what's your sense of the law on this?
You know, if you go back and read Reynolds versus Sims, citizenship was not an issue at all. And the language of that case, I mean, there are passages you could quote either direction. You know, there's a lot of discussion about total population, and there's a lot of discussion about equal weighting of votes, and you can kind of cherry pick what language you want to get either direction. So if it's a question of, you know, what the law is, I think I understand why the lower courts have taken the view that it's really a political question, and the legislative bodies are going to be allowed to make that decision. It's really not a legal issue, so to speak. That said, well, let me put it this way. I would be very surprised if the Supreme Court really dug deep into this. I think they're going to be mindful of the issues that we just talked about on the reliability of the data. I think they're going to be reluctant to tie the hands of states and say, you know, no Total population is not the measure, it's something else. But it wouldn't shock me if they looked at this and said, yeah, all that being so, we think there may be the extreme case that we would say just goes too far. You know, I mean, does anybody imagine that if you had a district, you know, I said before, California Senate districts are 800,000 people.
Right.
One of them has 799,000 voters and one has one voter. I think just about anybody would be a little disturbed by that at that point. I mean, at some point it gets so extreme that I think just about anybody would have a problem with it. And really at that point you're talking about where to draw the lines. And we were talking earlier at lunch, my big concern as someone who practices this area of law and who advises public entities on this is that what the court is going to say is total population's okay, but don't get too carried away on this citizenship thing. Go forth and redistrict and nothing else. And you know, you're as someone who's advising a public entity client, you're going to have to try and figure out what does too extreme mean. You know, does that mean 10? Is it the same 10% that you have to worry about for the total population? Is it something a little bit larger than that? The court has a way of sort of rolling these things out over 10 or 15 years. My fear is that the initial foray, if they decide to go there, is going to be very general and not give a whole lot of guidance into how to apply it. And then maybe over time, eventually, they'll start to do that. But, you know, it's...
So there'll be an invitation for a lot of work for people like you, right?
Well, I didn't say there wouldn't be a silver lining. No.
Right.
Well, and, you know, if they do that, you could also, depending on the details, every jurisdiction in the state or in the country may have to redistrict next year, which, again, would be good for me, but probably not ideal for stability of representation. You know, the state of, I've looked at the numbers, the state of California, if the theory that the Texas plaintiffs are pushing is upheld, the state of California is going to have to redraw its lines. I mean, their numbers are just about comparable to what Texas's are in terms of citizen voting age population. Tons of local jurisdictions have the same issue. So it's going to be a whole, you know, mid-decade wave of redistricting based on data that are 5 years old. So, you know, how far the court's going to go, I don't know. I would be surprised if they said total population is not a relevant measure, but I wouldn't be surprised if they start to deviate a little bit from that.
Okay. So it seems like Texas's position in this litigation is that the status quo should be preserved, which is to say that states have the option to use total population, but they can also use other measures as long as they don't violate other constitutional standards by excluding groups or so forth. So, so that's one potential option, is sort of a status quo preserving option. Another option is what the appellants are seeking, which is a new constitutional requirement that voting population or voting equality be taken into consideration, either in conjunction with total population or maybe exclusively, would be kind of the extreme option. Is there also a possibility that the court will take this opportunity to clarify this standard and say the total population is always the standard and we're not going to allow sort of local deviation from that?
I mean, I suppose it's a possibility. A couple of amicus briefs have argued for that. Common Cause did. The County of LA, actually, probably related to the history with Garza, and the Democratic National Committee. So, you know, whatever you think influence that's going to have on this court, I'll let you speculate. Maybe a negative one, I don't know. But the United States has weighed in as an amicus also in support of Texas. And they didn't come right down and say it should be total population, that's the only measure. But they got awfully close. And so I suppose it's possible, you know, if it were anybody but the United States, I would think, yeah, the court may not pay attention. But they read that brief for sure. And so they might, theoretically. I think they would have a hard time getting there after Burns versus Richardson. I mean, they've already said point blank, it doesn't have to be total population. You know, in this case, we think registered voters are okay. So unless they're going to overrule Burns, I don't see them going there. But you know, it's been pressed.
I'd also like to ask about local jurisdictions and how a precedent in this case could affect cities, counties, local districts.
It would be basically the same exact issue. You know, there would be less of a partisan well, at least in theory, partisan aspect to it. A lot of what's driving this case is Republicans versus Democrats. At least in California, our elected officials at the local level don't run as Republicans and Democrats. It doesn't mean people don't know where they fall a lot of the time, but it's not as formalized. Some states, there's more of that. But in theory, it's the same issue. The courts over the years have applied the same basic standard to state redistricting and to local redistricting. Congressional is its own thing, kind of the same basic idea, but much more stringent. And that's, I will say, that is not at all on the table in this case. No one is saying that using total population for congressional districts would be improper. I think everyone agrees that the Constitution actually anticipates that will be the measure for congressional.
In the local context, aren't there some anomalies? If there's a local jurisdiction that's got maybe a penitentiary in it, and those people are not eligible to vote,
Yeah.
how can that? So that could raise problems for total population as a standard at the local level.
Yeah, we've done some local jurisdictions like that, where we did a jurisdiction in the Central Valley where it was a total population of 15,000, of which 5 were inmates. And so if you drew 5 districts, you were going to have 1 2/3 districts in the prison, basically. None of them could vote because they're felons and they're disqualified. Following Burns, those jurisdictions, that type of jurisdiction has traditionally taken the prison out and said, we're just not going to include that in our total population number, assume if the court were to go and say, no, total population has to be the measure, I'm not quite sure what you would do in that case. And it's not just prisoners. It's colleges actually are a common area where that happens. Kansas, for example, will take the census data and it will go back and take out transient military and students. And if they're permanent residents, they'll reassign them to wherever they live instead of the base or the college, back to their home jurisdiction. So I suppose maybe that's a possibility, that the local jurisdictions with prisons could do that and say, those people don't really live here, they live wherever they lived before they were incarcerated.
You mentioned that the briefing on this has broken down sort of on ideological lines with right versus left. Do you have a prediction about the justices on the court and whether this will be a left-right 5-4 type decision, or is it the kind of thing that's a little bit more idiosyncratic and they might not break down on those lines?
If the plaintiffs win, I think it would probably be 5-4 at most. I think it would be probably a traditional conservative liberal split. If the state of Texas wins, it could be 9-0. I could see the conservatives on the court, maybe not Thomas, maybe 8-1, because he's already shown some interest in this. But I could see them saying, this is not something that we're going to wade into. They understand the politics, but I don't think that's going to decide it for them. And I think they could very well say, look, for 50 years we've said that jurisdictions get to make this choice. And some of these justices are ones who are particularly inclined to this sort of thinking anyway. Justice Scalia, I think, is going to be reluctant to say that there's something magic in the Equal Protection Clause that says that you have to use citizen voting age population. When the Equal Protection Clause was adopted in 1866, we didn't have citizen voting age population. That wasn't even a consideration. How could that have been, what it meant? And so from his perspective, an originalist perspective, I can't imagine him, or I could very easily imagine him saying, the Constitution just has nothing to say on this.
Okay, good. I think at this point it'd be a good opportunity to invite questions from the audience. Do we have microphones out there? And students get priority on questions.
We'd like to open up questions with students to priority. Are there any questions?
And if not, there's a question.
Hi, I'm a student. Human nature.
Humanity, yeah.
Where's Tom Hoffler on this? It seems to me that listening to this, I think back to the 90s when people were talking about the Census Bureau undercounting minorities. Mm-hmm. And everyone agrees that they do. And Democrats say that you have to adjust the census figures so to account for the real adjusted, imagined population. And Republicans were saying, no, 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 Constitution says, count it, enumerate it.
Well, first of all, by way of background, for those of you who don't know, Tom Hoffler has been the redistricting guru for the Republican National Committee for the last 40 years, I suppose. So, you know, you can kind of get a sense where he might stand on this. But that being said, I'm actually not sure, because we're talking about Texas and how if the plaintiffs' claims were accepted in Texas, it probably helps the Republicans. I'm not sure that's necessarily true everywhere. California, it might not. You know, yes, the urban areas tend to have more lower citizenship rates, and so they're going to be affected. But I think a lot of the more Republican rural areas are going to have the same issue in the Central Valley. And so what you might end up having is the districts that benefit are the suburban districts that are swing districts, but swing more, at least in presidential years, more Democratic. It could actually hurt Republicans in this state to have this rule adopted. So my guess is he's probably crunched the numbers in every state and every district in the entire United States and figured out where that lands. But no, I won't speak for Tom. I don't know where he is specifically. But I do think that from a partisan perspective, it's not as clean cut as this case might make it look. I think it's partly a fact of where it's being brought.
It used to be the Republicans didn't want the adjustment and the Democrats, yes,
Yeah, right.
and the Democrats did, and now in this case the Republicans are asking for the adjustments and the Democrats are saying, no, 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 no,
Right.
take what's counted.
Yeah.
The other issue is what's happened to that old debate about the Census Bureau. That's a Democratic president, Democratic appointed Census Bureau. Why hasn't that come back, or has it come back and I haven't heard about it?
Yeah, it's gone more low key. So in the early years of the last cycle, like 1999, I think it was, the Supreme Court, there was a case about whether you had to do sampling or the actual count. And the Supreme Court said it has to be an actual count for reapportionment, for purposes of deciding which states get which representatives. And that kind of answered a big part of it, because that's who was driving those cases. But with respect to this issue of one person, one vote, states have picked and chosen. The Census Bureau has put out adjusted data alongside its actual count, and states have decided which they're going to use. So the bluer states have used the adjusted data, and the redder states have not in a lot of cases. And a lot of the states will also do what I talked about with Kansas. They'll particularly prisons. That's been where a lot of this activity happens. They'll readjust people back out and say, no, you don't live here where the prison is. You live back there where we picked you up, where you lived when you were arrested. And so a lot of states actually do a little bit tinkering around the edges before they draw their lines. But that's why it's been quieter, is that the baseline question of reapportionment has been answered by the Supreme Court.
You've talked about issues of practicality with instituting voter equality. My question would be, is there precedent for the Supreme Court to face an issue that where one of the solutions might be very impractical, or there might not be a practice in place to institute that, and has said, this is how we see it, now you have to figure out how to do it? Is there precedent for that?
Probably half their cases, right? I mean, no, but all kidding aside, the 60s redistricting revolution, that's what that was. Before 1962, in Baker versus Carr, the courts had said, we're not getting into this equal population thing. We don't think the courts have any business doing that. That's a legislative decision, and we're not going to interfere. And in 1962, they changed course and said, no, we're going to hear it, and then 2 years later, we're going to hear it, and it has to be equal population. And then they worked out what that meant over the course of, basically 20 years. So it was up until the mid-'70s before we actually got the 10% rule and knew what equal population meant. And of course, it's a different rule for congressional districts. If you're off by a little bit in congressional districts, you can be in trouble. The courts, it's not at all unprecedented for the court to sort of work out those logistical details after the fact. Some people accuse them of legislating by doing that, but it wouldn't be the first time they've done something like that. And that's, as I said, what I'm afraid of. They'll lay down a broad rule now and then work out the details, over the next 15 years.
Chris, I want to follow up on what you said about the state versus federal districting. I think you mentioned that the state legislatures, if they're districted within a maximum deviation of 10%, that's presumptively constitutional, but the court has also said when it comes to congressional districts, districts have to be as equal as possible, and with the technology we have, that can be down to just a few vote or a few head counts difference. Do you see how do you see that playing out in this question? Would the court give greater leeway to the states in terms of using whatever method they wanted, whether it's voters or population or some combination or variation of that, and maintain the strict requirement of equal population for congressional districts, or would that have implications for congressional districting then also? Well,
I think there's two different aspects to that. One, in terms of this, how stringent the federal thing is, Daryl's right. There have been cases brought where the deviation between the largest and smallest district were about 5 people. And the courts have said, no, that's too big, you could make it smaller. The Supreme Court, in a case out of West Virginia a few years back, said, let's not get crazy about this, right? The state of West Virginia had deviated by like a couple percent, I think, so they could keep counties intact. And the court said, we're not going to get ridiculous. That's fine. That's not hurting anybody. It's only a couple percent. And so they've shown a little bit of willingness to back off a little bit on how strict they're going to be. In terms of the relationship between the state and the federal, as I said before, I don't think there's any chance that the citizen voting age population issue bleeds over into congressional. I think everyone agrees that the Constitution requires representation on the basis of total population. If you read through all these briefs, the plaintiffs, they all concede that because the language is pretty clear on that. So I could see potentially the court, if it decides to require some sort of citizenship aspect, loosening up the state standard a little bit and say, yeah, 10%, but if you have to do it to meet this citizenship thing, maybe 15% is okay. And so they might be a little bit less restrictive in that sense. But I'm not sure I see it having huge implications for the federal congressional redistricting, at least not right away.
Hi, another former student. I just wanted to follow up on the sort of eligible voter issues here, because obviously states set their own rules for voter eligibility. In fact, even citizenship, before the 1920s, it was fairly common to have non-citizens with the right to vote. And certainly rules on like prisoner voting, felon voting, and things like that are constantly changing. And so my wonder is that if the courts were to adopt some sort of citizenship or eligible voter measure in the equality, how would sort of emerging or changing rules, how would they be able to adjust, or would it not be able to adjust? Would that be something that the courts even consider in this case, do you think?
Well, I think they will take it into account. States have a lot less leeway to decide who gets to vote than they used to, right? A lot of that has been overtaken by federal law over the years. So, in terms of age, it's 18 now, period. It was statute and then constitutional amendment. In terms of citizenship, there is still some play, and especially you mentioned the prisoner rules. That may it's already been something of a hotbed of litigation over the years. I think that would ramp it up potentially. If the court said it has to be a citizen voting age population, eligible voters, it's going to be more important and more of a factor. It's already sort of a factor, but I think, you might see states become either more or less strict about which prisoners are allowed to regain their voting rights and under what circumstances. And then, of course, lawsuits over that, inevitably.
So if you accept the plaintiff's theory, which is say that you need CVAP or you need some other voter-based metric, then where's the end line after that? Like, is there a point at which you could end up relying on voter turnout numbers, or they could end up relying on some other voting-related number, but just not total population at some point down the line if you accept the plaintiff's theory?
Well, I mean, I suppose the end point is probably registered voters. That's probably about as restricted as you could get. If you do actual voters, then I think you have some real problems, because that, varies much more wildly. The smallest population group in terms of this tends to be the registered voters, because those are people who are obviously eligible and then took the time to go and fill out the forms. And it's not always a huge gap. And, it's a lot of states, it's so easy to register to vote. I mean, California, well, this is actually an interesting issue. California has passed a new law that is essentially going to automatically register you to vote unless you opt out when you go to get your driver's license, assuming you meet the eligibility criteria. That's going to presumably drive up that population base, and you may see other states follow suit if the court decides that is the rule. So, in California, you don't even have to be a citizen to get, you don't have to even be in the country legally to get driver's licenses. So, I don't know.
Maybe on this point, to Justin's point, what do you think is the prospect of a state, California, might be the leading candidate, granting voting rights to non-citizens?
I don't think it's completely inconceivable. As he said, it's happened before, and there are always ongoing discussions about certain cities trying to do that. It comes up a lot in jurisdictions with a lot of snowbirds actually run into it. It's not citizenship, but it's residence. People who are here maybe a few months out of the year, they're registered somewhere else, but they own property here and they're here a lot. Should they be allowed to vote? And some jurisdictions allow them to. So I could see potentially a move that direction. I think, it's not a big surprise. You'll have a lawsuit because the 14th Amendment, you have Section 1 that talks about equal protection, but then Section 2 hasn't really gotten a whole lot of attention in this case, says that, to the extent that the rights of voters are abridged, and it defines voters as male citizens above the age of 21, then congressional representation is supposed to be affected. Now, obviously, the 18th Amendment, not the 18th, the 19th Amendment,
yeah.
and the 26th Amendment have changed the over the age of 21, and they've changed the male voters, but they haven't changed the citizenship aspect. So I suppose there's an argument that if you were to do that, you would be diluting those voters' votes, and they might bring a claim under that provision of the Constitution.
Hi. Do you think there's any chance that the court would limit their decision to only apply to Texas and sort of deal with this on a case-by-case basis rather than issuing a broad decision like as they did in Hawaii?
Well, yes and no. In the sense that, yes, I think if they issue the ruling that I'm afraid of, which is don't get too extreme, they might say Texas is too extreme. So you'll know what sort of your outer limit is, but they wouldn't tell you within that what it is, and they work that out over time. But I think they're going to have to lay down some sort of rule to give you at least a little bit of guidance. And if it's Justice Kennedy writing the opinion, it's going to be sweeping, and it'll apply to everybody. Just a guess. My expectation is that's who everyone's writing for, because that's who they're always writing for.
Any other questions?
Are there any more questions? Well, please join me in thanking our speaker.
Thanks all for being here.